Great. So happy to have you here with us, Matthew. Welcome. My name is Taylor. We would normally do a welcome everybody that's here, but here we are doing a recording for our September Renters' Rights. And my name is Taylor. I use they, them pronouns. I am the Program and Development Manager at LGBTQ Allyship. I do want to take one moment just to thank first, to acknowledge that we are on Indigenous lands, the traditional territory of the Coast Salish peoples, specifically the Duwamish tribe. And I'd like to invite people to learn more about the Duwamish tribe and sign their petition for federal recognition. And you can go to their website and consider also paying rent. We're here talking about renters' rights, and we pay rent to our landlords, but we would like to also acknowledge paying rent to the Duwamish tribe, and you can visit them at realrentduwamish.org, and that's DUWAM as in Mary, ISH. Thank you. So I'm excited because I am here joined with Matthew from Entre Hermanos, and would like you, Matthew, to introduce yourself.
So I apologize. I might be clearing my throat a little bit throughout the video. I'm getting over a cold right now. But thank you, Taylor. So my name is Matthew. I'm the housing case manager at Entre Hermanos. My goal with the organization, my role is right now specifically, we are participating in a federal program with the city of Seattle that is helping us, some of our clients access short-term and permanent housing assistance. So clients who need help with their rents, payments, or their utilities, we're helping them make those payments there. Or for the clients that are looking for more stable housing, we're helping them find that assistance there. Hopefully we'll have this program long term with the organization, but for right now it's only until February 2024. But we're starting to work with the clients here, specifically, or in particular, I should say, with clients who are Hispanic and LGBT identifying.
Awesome. Thank you for doing that work, and it is great work. So typically I would ask if anybody has any questions. We are going to just dive right in since this is a recording for today. So let's go ahead. Why? First of all, why is it important to know your renters' rights, especially as LGBTQ members of our community? And one of the reasons why is because LGBT renters are 41% as opposed to our heterosexual renters. They're at 25%. So we really are a larger portion of the community that rents and compared to the non-LGBTQ members, meaning that LGBTQ and specifically trans and LGBTQ people of color, elders, and LGBTQ members with disabilities have a higher rate of rental discrimination. So there are some anti-discrimination laws that are out there, and the Fair Housing Act, so that you all know, is part of this wonderful way of making sure that we aren't discriminating around housing and housing related discrimination. And they are based on color, race, national origin, religion, sex, gender identity, sexual orientation, family status, and disabilities. Those are through the Fair Housing Act. Recently, there has been an executive order, an executive order that has been made on January 20th of 2021. President Biden issued this executive order 13988 on preventing and combating discrimination on the basis of gender identity and sexual orientation. So this is United States of America wide. It's not just Washington. So the Fair Housing Act does cover Washington, and that is explained through HUD. And it brings up a really great part that Matthew and I were talking about earlier around your national origins, sorry, and being, if you're an immigrant in Washington State and specifically Seattle, you do not have to help me out here, Matthew. You don't have to be, what's the word?
Documented.
Recording. Huh?
Documented.
Documented, yes. You do not, sorry, hearing disability. You don't have to be documented to apply for housing. You do not have to be, and we're also trying to rule out the whole, you must have a social security number and all that stuff too. So we're working on that. So just so that you know, you do not have to be documented to apply for housing. Please do not feel like that is a reason not to apply for housing. All right.
And I'll make a point on the term documentation, because a lot of folks will consider that the lack of social security number, and that's in most people's cases, but lack of documentation could also be a lack of birth certificate, for example, or other forms of like documentation that folks use in terms of identity. Most government programs will have various forms that you can have as an alternative if you don't have that form of those forms of documentation. And a lot of times, if you're not able to provide those documentations that those programs are offering, you would have to check with the agency, of course, that you're working with. But you can also, like for our clients, for example, we can provide verifications from our agency.
Awesome. I didn't know that. That's perfect. This is why we're working with you all. So great. That's more information than I even knew, and I just learned something new. Thank you. So one of the laws that I wanted to talk about is the just cause eviction ordinance. And this is really important because it goes across the Washington state. We're excited because this law was placed in Seattle in 1990s, but now being statewide, it helps so many more people. So the just cause eviction ordinance was passed. And what does it do? It was a huge hats off. The only like real good thing that might have come out of the pandemic was this. It was to help reduce the landlords being able to kick people out. So in writing, it must state from your landlord one of 18 reasons in writing as to why they are asking you to leave. And let me think here. If you are in a 6-month or a 12-month lease, it protects you as a fixed lease. So they have to give a notice as to why. And then if you are now in Seattle, and this is not the case statewide, but for Seattle, if you're in a month, they have to provide a just cause reason also to not renew your, not to turn it into a lease. So if you are a month-to-month renter in Washington State or Seattle, I'm sorry, no, just Seattle, no matter what kind of rental lease you hold, there has to be one of 18 legal reasons why you can be evicted. Some of those reasons are consistently paying late, paying your rent late, violating your rental term or agreement, or if your landlord wants to move into the unit, and if your landlord lies about getting you to move out, for example, if you never, and they never actually moved into the unit, you actually can sue them. That has happened more than once, many times, where landlords, especially during COVID, were saying that they were going to move in, and then something, or a family member was going to move in, but they never did. So you can take them to small claims court. The amount is for 2,000 and damages. It's not that much, but still states a purpose. For a complete list of reasons, you can go to the Seattle Department of Construction and Inspections Renter's Handbook. There's a whole handbook, and it gives you all 18 reasons. And you can provide this, and we can send that to you if you request it from LGBTQ allyship. One more thing about the eviction moratorium that I wanted to say is, I lost my place. Be sure that you know, hold on a second. Landlords have to date that eviction notice. It has to be time-stamped, dated, and you have to reply back to them within a reasonable amount of time. If they don't timestamp it, then you can also rebuttal it, say that there's a reason that they say, like, you don't ever pay on time. And if it was just one time, you can rebuttal that. So just wanted to kind of put that out there to know that there are ways to get around that too. So the other one, another law that I think is really important, is a first-time ordinance. So this law, do you know about this law, Matthew? First in time?
Yes, a little bit. Sorry, I was trying to find the mute on my
No, that's fine.
computer.
Now my dog's barking. So you do know about it? All right, gotta quiet that dog. Yeah, so this is such a great, it's not the greatest law, I would say. We are actually challenging some things because landlords do try to get around this. But first-time ordinance was designed to require a landlord to offer a rental agreement to the first qualified applicants who submits a complete application. The landlord or property manager must fully cooperate with the applicants using a housing subsidy, such as completing the paperwork that's needed for a housing subsidy. Landlords are to date and timestamp again the application in order that they received them. Screen the applicants in order at one at a time. Give applicants a minimum of 72 hours for additional information, and then complete the application and provide 48 hours for a response if it's incomplete before moving to the next applicant. The best way to be ready for this is, because we know that these kinds of things are really stressful, is to, as listed, know your credit report, know what's going to come up, let them know what you're, if there's something that's on your credit report that you're like, yeah, I know that's there, and this is why, have a reason. Current and previous addresses, have them on, like, in a list of a book or something, so that you can easily put those down. Name and birthday of all the occupants that are there. And you do, if your name is, if you're a non-binary person that uses a different name than your birth name, you do need to use the name that's on your birth certificate. If you had that court change, like I have, you can use the name that you have on your name change. So make sure that you're using your legal name. And then references, personal references, housing references. If you have had other landlords, have them write a reference. If you haven't had a landlord, but you've had a roommate and you rented a room from somebody, have that reference. If you've never rented before and you're just getting into renting, have a personal reference or a work reference. Give you some kind of reference. Vehicle information, if you have a vehicle, make sure that you have your vehicle information in there. And then reference to housing related information. Pet information is the other one that's important. If you have pets, be honest about that. I know that there's lots of reasons why people aren't. I hadn't been when I was younger, because they were always wanting to charge you pet fees and all that stuff. But you'll want to make sure that you're not doing that, because it has become costly later. So if the second, does all that make sense right now so far that I'm saying to you,
Mhm.
Matthew?
And one
Okay.
of the things I was going to mention also for folks that might come up is co-signers might be required in the application process if you have a lack of a credit report, especially if you're a younger person who hasn't rented before. Like select a co-signer ahead of time rather than trying to get the co-signer when the landlord tells you that you need a co-signer. The co-signing process could take a little bit, especially if the papers need to get to the co-signer and then get back to the landlord. So better to have that person already aware that the ahead of time. Another
Very
thing
good.
also for folks that don't have a credit report or might have bad credit, having pay stubs available or another form of income verification available is also a very good thing. Especially again for folks clients that may be undocumented. For example, again, if you're not, having a bank account sometimes or not having any form of credit report, another form of income verification like that would be helpful.
Yes, good call on those. Thank you for putting those in. And the landlord does charge for application screening. If you should not be charged anything else though during an application screening. And it can be 25 to 45 per adult. And applying that is considered reasonable. If your application is denied, they do have to provide you a reason for the denial. This is called an adverse action notice, which is required by the city and state. One of the things that I hear a lot are people are being told, well, you need to come and look at the unit first before you apply for it. And that is a way for them to meet you and make a determination. And then possibly if they decide they don't want you or whatever their reason is, then they can say, oh, somebody already filled out an application. That is not following these first time ordinance. So if somebody tells you, a landlord tells you you need to come look at it or any of that, ask them for the application before you even go over and see it. That's my suggestion for right now. All right. Another question that's been coming up a lot are issues around notices. So I wanted to talk about that. And my screen is being really weird on my end. So hold on a second. Okay. All right. Notices to this time. Here we have. There's these different notices that have come up. I think I know why I don't have this one on mine. So there's all these different notices and I need to look them up again to remember exactly, but did I send that to you, Matthew? And yours?
Let's see, are you having trouble seeing the 30-day notice, 10-day notice, that screen?
Yeah, I
Okay,
sent, I didn't, or I feel like I don't have that copy, but I
oh,
will grab it real quick too. Go ahead. If you have it, I would love
I will
for
double
you
check
to
if I do.
go.
1 second.
I just found it now, I believe. Here we are. I got it. I found it. Okay, sorry about that. Issuing notices. So your landlord has these different kinds of notices that they can issue you. A 30-day notice, 10-day notice, 14-day notice, 3-day notice, and a non-renewal notice. So what are these different notices? If you change from month to month rental agreement, your landlord must provide you, the tenant, with a minimum of 30-day notice advance in writing. So, and this has to be in writing. It's not an email, it's not a text message, it's in writing. Um, a lot of people say, well, they texted me. That's not in writing. Um, these changes can only be effective in the beginning of a rental period. The 30 days cannot include the day you were served the notice. So under the lease agreement, terms cannot be changed unless by mutual agreement between you and your landlord. Be sure to record any agreement upon the changes in writing and have both parties sign and date any changes to the lease. 10-day notice is a complement to vacate. So, sorry, that 10-day notice is a different thing. 30-day notice is what we're talking about. So be sure that you get this in writing, a 30-day notice change. Again, this is month to month rental agreement changing to, say you're renewing a lease, say you're a 30-day and you're going to start a lease. It needs to be told to you in 30 days. If they are not going to renew that month to month, your month to month is going to end, they need to give you 30-day notice. So what is a 10-day notice? 10-day notice is comply or vacate. This is usually one of those like pay or vacate, comply or vacate, or you've breached a rental agreement, or say you've been paying late, or you haven't paid, then they can give you, it can also be used to collect late fees or notice fees. So they can give you 10 days to ask you to agree to complying for whatever payment is due or vacate. A 14-day notice is pay or vacate is only appropriate for collecting late rent. Okay, so I just screwed that up. Back up a second. 10-day is comply or vacate because you breached a rental agreement. 14-day notice is collecting late rent. Rent, including parking, utility, storage, late installment payment plans. So say you're on you are repaying due COVID repayments and you have an agreement and you haven't made that payment, they can give you a 14-day notice. It does not include late fees, notice fees, etc. So, which may make the notice invalid if it is included. So if they're saying, well, you need to pay the late fees and blah, 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 it's not a 14-day notice of pay or vacate, it's invalid. A 3-day notice is for waste and nuisance. It is the most serious kind of notice and issued to a tenant because it does not provide an opportunity to correct a violation. So this is where if you are, I don't know, playing loud music every night and trashing or throwing trash literally outside where people are walking and you're not putting it away, not having it disposed properly. If you're a nuisance because you're standing outside screaming and violating other sound ordinances and things like that. That is a 3-day notice. And a non-renewal notice is required when you have a just cause to end a lease when it expires. So remember the just cause notices information, one of 18 reasons why they're not renewing. Legal counseling is always recommended when you need to issue a notice. And if you get one, you can do the legal counseling, technical assistance, or rental regulations. And you can call the Seattle helpline. I feel like Matthew would be another person that you could call. The phone number for Seattle helpline, though, is 206-684-5700, and they will help you know. So if you get any of these notices, they'll let you know if it's legal or not too. So it's a really great resource to use. Yeah,
Yeah,
anything else?
I'll drop my phone number also, if especially for folks that are English second language. I speak Spanish and Portuguese, so I can speak both if need be. But my number with Entre Hermanos is 206-274-8334. So again, it's not in my area specialty in terms of notices, but we do have legal consult with Entre Hermanos, and we can help in cases where folks have been served those notices and see what sort of legal assistance we can.
Awesome. So normally we'd say if there's any questions, do you have any questions, Matthew?
Well, not questions. One of the things I wanted to mention for folks also, because this is a very recent change in government since Biden's administration. For folks looking for housing assistance programs, for a lot of folks that are seeking housing assistance programs, prior administration that had been considered a public charge note. So for folks that don't know, public charge is a consideration for a person that is how do I put it in a way? I'm not very fond of the whole notion of a public charge, but it's a person who the government considers someone that the government's essentially taking care of in some way. So for example, supplemental assistance, that's considered a note for public charge. So the more assistance that folks get, the more that kind of ticks off boxes for them being considered a public charge, quote unquote. So a lot of folks are hesitant when they're applying for residency or documentation to get those assistance, is because if they get noted as a public charge, it's less likely that they will receive their documentation. Not a great concept, I'll be honest, that I'm very fond of. But on a positive note, that there's been a recent change in the government, so housing assistance is no longer considered a public charge note. So folks that are scared, that are getting their documentations and are scared to get those housing assistance programs, it's not going to reflect badly in your application process at all. So please feel free and look out for those relief funds and those assistances out there.
That's great. Yeah, and that's really helpful to know. Yeah, my dog apparently has some questions. So here's the pug. See, hi. Oh, anyways, she's just trying to mess up the program. So if anybody does have questions, it sounds like you already gave your phone number. but they can also reach you at
Yes,
your email address.
Yep, its email address is Matthew, MATTHEW @entrehermanos.org.
And if anybody has questions for me at LGBTQ allyship, it is taylor@allyship.org. So that is the wrap. And my dog said it's time to be fed. So I guess we're good. I appreciate your
All
time,
right, thank you so much,
Matthew,
Taylor.
and thank you. And I will talk with you real soon.
Yes, thank you.
I will stop the recording.